The present proceedings was started in the year 2015 and the appeal was filed in the year 2018. Thus, respondent number 2 had jurisdiction to decide the same stuff. This court in Ajay Kumar Srivastava under bracket Supra had already held that the power of delegation was there in view of section 76A of the Act, 1899 and reliance placed upon decision of Neetu Agarwal and another under bracket Supra cannot be accepted as the same was given in the year 2009 and UP amendment came in the year 2015 and the notification was issued by the state government on 24/5/2017, well before the appeal was filed by petitioner before respondent number 2 staff para. Now coming to the second argument raised by learned counsel that petitioner has purchased the land in question after declaration under section 144 of Act, 1950 and thus was not entitled for payment of stamp duty on the basis of report that the land in question was a non-agricultural land staff. Here it would be necessary to refer to the action initiated on complaint made to Lokayukt in respect of evasion of stamp duty in District Mathura from the year 2007-08 to 2013-14, wherein it was found that in number of cases, after getting declaration under section 143 of the Act, 1950, the land was being transferred through sale, was again converted as an agricultural land and declaration is sought under section 144 of Act, 1950 star. No plausible explanation has been accorded by the council as to what was the need in the year 2009 to have the land converted back as an agricultural land when once the declaration under section 143 had already been made on 16/7/2005 star. From the perusal of the order passed by Sub-Divisional Magistrate, Mathura dated 16/7/2005, it is clear that on the application of the original landholders, it was found that the land in question was not being used for agricultural purpose, and on the basis of the report being received from the office of Tehsildar after inquiry that the declaration was made by the concerned officer staff. The subsequent order made under section 144 of the Act, 1950 does not record any ground for making such declaration once it was found to be land not being used for agricultural purpose, staff para. As the learned additional advocate general has pointed out that this is not a solitary case and on an inquiry by the Lokayukt, it was found that between 2007 to 2014 there were number of cases where such declaration was made under section 144 of Act, 1950 for the purpose of escaping the stamp duty, I find that the district revenue authorities rightly proceeded to hold deficiency of stamp duty on the basis of the fact that once the declaration was made in the year 2005 under section 143 of Act, 1950, no occasion arise for getting the land again converted as an agricultural land just for the purpose of sale deed and evading the stamp duty. Stop.